Hi everyone, I'm Advocate Udit Kapoor working as a legal associate at NRI Legal Services. Registration of an immovable property is both a statutory and a prudent practice that is eminent for transfer of property in India. The burden for registration of an immovable property lies on the buyer. Therefore, today I will apprise you with the steps involved in the registration of an immovable property purchased by a non-resident Indian, that is an NRI. Before we look into the steps involved in the registration of a property, it is important for us to focus on first, what is the criteria of a non-resident Indian? Second, an acquisition of an immovable property by an NRI. Third, the essence of registration. Fourth, what are the consequences for non-registration of an immovable property? Fifth, what is the registration fees involved? And sixth, what is the time limit for registration? Who is a non-resident Indian? In layman language, an Indian citizen residing outside India for business, employment, or any other purpose for indefinite period of time is regarded as non-resident Indian. However, the statutory status of a non-resident Indian is ascertained under the FEMA Act and the Income Tax Act. As per the FEMA Act, an individual's residential status is ascertained on the basis of that individual's intention to stay in India, wherein under the Income Tax Act, an individual's residential status is determined on the number of days that individual stays in India. In a recent amendment, the number of days under the Income Tax Act have been reduced from 182 days to 120 days. Therefore, if you are residing outside India and are not covered under any of the two concepts being explained, you will automatically be deemed as a non-resident Indian. Now, we will discuss about acquisition of an immovable property by a non-resident Indian. It is a common misconception that being an Indian citizen, a non-resident Indian is permitted to buy any sort of immovable property. However, according to the Reserve Bank of India's Master Circular on acquisition and transfer of immovable property by NRI, PIO, or foreign national, an NRI is strictly restricted from buying any agricultural land, farmland, or plantation land. However, this does not mean that an NRI who has an existing ownership or in a near future may be given a ownership based on succession to such properties will be restricted or null and void. Furthermore, an NRI does not require any sort of special permission or permission from Reserve Bank of India to purchase any number of residential or commercial properties in India. Now, we will discuss about essence of registration. Registration process and other intricacies thereto are governed under Registration Act. To understand the registration process better, it is important for us to understand the constitutional intent behind it. The apex court in the matter Suraj Industries Private Limited versus State of Haryana and others duly observed that the Registration Act came into being in order to provide orderliness, discipline, and public notice for all the transactions relating to immovable properties, and further preventing any sort of forgery. Furthermore, once a document is been registered, it becomes a public document as it is available readily in the public domain. Such a public document acts as a caveat towards the general public in regards to any legal rights that are arising out of or affecting an immovable property. It would further prevent any sort of misrepresentation or forgery of documents. Now the question remains, are all documents required to be compulsorily registered? The answer to is no. The documents which are covered under section 17 are compulsorily required to be registered. Therefore, it is to be taken into account all the documents that relate with transfer and sale of an immovable property and are more than a constitution amount of ₹100 and are not testamentary instruments are required to be compulsorily registered. This would include documents such as sale deed. Now, there are certain documents that do not require compulsory registration and are covered under Section 18. Such documents include wills, power of attorney, and even agreement to sale. Now, we'll discuss about what are the consequences of non-registration. As discussed earlier, there are certain documents which are compulsorily required to be registered, and opting out of the same would incur a particular individual legal injury by, first of all, invalidating the legitimacy of any transaction that has consequent sale or transfer of a property. Secondly, invalidating the evidential value of this particular transaction in the eyes of the court. And lastly, it would pave path for misrepresentation and fraudulent activity. Now, we will discuss about the stamp duty. A buyer is bound to pay a certain amount in form of tax levied by the state government to generate revenues. This is usually a small percentage of the saleable value of the property that amounts to, in most states, 1% of the value of the property. Now we will discuss about time limit for registration. The time limit for registration of any compulsorily required document under the Act is within 4 months from the date of execution of such a document. If it happens to be so that you are not able to register this particular document in the stipulated time period, you are still given the time to register this particular document in succeeding 4 months. Now, if you're not able to register the document in the succeeding 4 months too, yet you are given an opportunity to register this particular document by annexing a confirmation deed along with a stamp duty paid on the current market value. This document would further be taken to adjudication before the collector and then would be registered by the joint sub-registrar. Therefore, it is recommended that rather than taking this expired document, which has already passed 8 months from the date of execution, you shall prepare a fresh document. Now, we will be discussing about what are the steps that are involved in the registration of an immovable property that has already been purchased by a non-resident Indian. All documents in regards to sale and transfer of immovable property are to be presented before the sub-registrar's office, in whose sub-district the subject property is located. It is to be noted that it is the discretion of the officer at this sub-district's office to be present in any residence of an individual who desires to register a document with regards to an immovable property. Furthermore, such documents require proper representation before the sub-registrar. Therefore, the buyer, the seller, and the legal representatives have to be physically present before the sub-registrar's office. In case of a legal representative or an assignee, a proper power of attorney has to be produced before the sub-registrar. Now, in case where the vendor dies, signing a particular document which is pending registration, the document can still be registered provided the legal heirs have been implemented by the purchaser in the following manner. First, you can move an application in the Honorable Court for an probate or an order that tends to implead the legal heirs to represent the demised vendor before the sub-registrar. Secondly, you can prepare a deed of fact that entails all the facts in regard to the demised vendor. This deed has to be duly signed by the purchaser and the legal heirs, and once it has been done so, the sub-registrar's office would deem this as to be a proper document for registration. Now, the authorized signatories have to present a proof of identity, which includes PAN card, Aadhaar card, or any such document that has been authenticated by the government as a proof of identity. In addition to these documents, original documents that have consequent transfer of the immovable property, such as sale deed and a proof of stamp duty and other prerequisite documents, are to be presented before the sub-registrar for a successful registration of the immovable property. Hence, given our discussion, it can be concluded that the registration of all the documents related to immovable property is compulsory in nature, and further, the steps involved in the registration requires a good understanding of the legal intricacies. Therefore, I would advise that a proper legal assistance shall be taken for registration of an immovable property. I hope you found this video insightful and informative. If you have any query, please feel free to write us at query@nrilegalservices.com. Thank you.